to stand up while you're speaking. Once we get going, the session clerk will display a countdown clock. Each side has 15 minutes to argue. I understand that the appellees are splitting their time 10 minutes, 5 minutes. Is that correct? Okay. And there's no rebuttal. Only one advocate can speak at a time, and so when it's not your turn your turn to speak, the clerk will actually mute your feed, but we'll still be able to see you. So please keep your reactions and gesticulations and such to a minimum. And as you know, or maybe you don't know, the proceeding is being recorded and archived, so it will be accessible to the public. As you know, this case is an impounded case, so we'll be using pseudonyms. We won't be referring to the parties by names, but rather by their mother, child, etc. As always, we have read your briefs and we're familiar with the case. And although you have 15 minutes, you're feel free to use all of it or most of it. You don't have to use it all if you don't need to. So we're going to call the first case for today, which is 19P1421, Department of Children and Families versus Mother. Attorney?
Good morning. I'm Attorney Catherine Foster, representing appellant Mother in this case. May it please the court. This case presents two questions. And the first is, does a 5-page summary of facts followed by 7 pages of boilerplate law constitute specific detailed findings showing that the court paid close attention to the evidence? And second, is it lawful in Massachusetts for the department to seek to terminate a mother's parental rights when the department admittedly made no effort to accommodate the parent's obvious disabilities? And does it matter if the failure is part of a larger pattern of systematic discrimination against parents with disabilities? For the first question, Mother suggests that the answer must be no. A 5-page summary of facts with no numbered paragraphs, credibility determinations, or references to the record does not constitute specific detailed findings to rise to the level of showing by clear and convincing evidence this mother was unfit.
I'm sure you read the DCF brief that there's no requirement in juvenile court that the paragraphs be numbered.
I did see that, and I concede that it was a district court rule that I did use, and that was my error. But it is just so hard to have 5 pages of summary with no references to the record, and the lack of numbered paragraphs, which is customary in juvenile court decisions, even if it's not required by the juvenile court rules. It makes it so difficult for counsel as well as for this court to provide a meaningful review. The lack of any reference to the record, and this record is thin as it is, and it has contradictions within itself. So especially in a case like this, where the record is so thin and where there are credibility issues, such as the fact that the department cites in 7 times in only 15 documents that mother became unaccounted for after having the baby. But it's also clear that the department social worker was speaking to mother's hospital social worker, who said that she was still in the hospital during some of the time when these 72-hour hearings were happening, that she's accused of not showing up for. If the court doesn't provide any kind of connection to where it is drawing its conclusions, it is really hard to provide the kind of, first of all, it would seem inappropriate for the court to provide the normal kind of review, which is deferential, if the court doesn't know if the conclusions are coming from testimonial or documentary evidence, given that the standard is different for each.
I'm sorry, the standard is different for a judge's findings. It's based on a document as opposed to testimony?
Yeah, the references that I have for that are adoption of Rona, this court shows deference to the conclusion, but also to findings from testimonial evidence, but without credibility but de novo review for findings created from documentary evidence, because this court can, the rationale is this court can look just as easily at the documents as the trial court could have looked at the documents and draw your own conclusions. And that is in Commonwealth of Revenue versus Comcast Corporation and Commonwealth versus Tremblay. And those are both cited in my brief.
So can I just on the merits, although it is a thin record and the findings are not as detailed as we sometimes see, it's pretty clear the basis for the judge's findings, and your client has some very substantial deficits, and you're not arguing that she's currently fit. Is there any evidence in the record from which we could determine, or a judge could determine, that she's likely to address those deficits and become fit in the foreseeable future?
Unfortunately, I don't think there's good evidence either way. There's no evidence of parenting, really, because she was afforded such limited opportunity to have contact with her son. And so there's very limited evidence of any accommodation. I mean, this mother has had contact with DMH, DDS, CHD. She had all of this constellation of needs were being addressed by agencies tasked to address these needs. But when it came to her needs as a parent, the department says they were concerned about her becoming stable. Well, that wasn't their job. Their job was to provide parenting resources, was to strengthen her family, just as the department's mandate is to strengthen all families.
Without her stabilizing, as long as she's going into mental institutions, there's no way to work on that, stabilizing her mental health. Why isn't that the first priority in trying to get her reunited?
I'm not saying it's not the first priority. I'm saying that there were other agencies tasked with that job, and that the only job that DCF had, they didn't do in this case. It sounds like the social worker called, around to mother's collaterals. She signed regular releases so that the social worker could make contact with her collaterals, which is often a problem in this case. But mother, at least according to the social worker, was actually cooperative with these releases. But the social worker then didn't use any information provided by or evaluations provided by these agencies to develop service plans to help mother parent. And in fact, in the service plans, they required mother to act like an able parent, to ask questions, to do things on her own. The department didn't work with any of her collaterals to help provide assistance to parents, which is DCF supposed to be the expert in this, not in whether she's stable, which they could have worked with other agencies to determine, but instead they didn't.
Counsel, the issue of reasonable efforts was not raised to the judge or to the department. Do you agree with that?
I have two responses to that. The first is, we don't know from the record whether reasonable efforts were raised to the department, because it would have been in conversations with the social worker over time. So we don't have a record of any of those conversations.
Well, it wasn't, there's no record of it, fair hearing being requested or anything of that sort. Is that right?
That is true. Well,
Okay.
and the other response, I'm sorry.
So isn't the case law fairly clear that this issue has to be raised in order for us to be able to review it on appeal?
If I may, I have two quick responses. The first is more to the question you asked earlier, which has to do with, I didn't argue ineffective assistance of counsel because mother's subsequent counsel was effective, but I think that whether or not reasonable efforts were contested seems to fall in that kind of area for the, anyways. Okay, so that's my first response. The second is the case law clear. And the case law is clear that the department needs to have notice of a parent's disabilities and of their obligation to make accommodations. That was the rationale and adoption of Gregory for declining to recognize or allow the failure of reasonable efforts to be a defense determination. And I'm saying in this case, can easily be distinguished in the sense that it's hard to imagine a case that would be more obvious that this mother has disabilities that need to be accommodated. Just the way the case came in, her intellectual disabilities and kind of understanding things that were going on. The department had more than sufficient notice. They admitted at trial that, yes, they knew she was disabled. And they also admitted at trial that no, they didn't do anything to accommodate her disabilities. And I think this case raises that question. Is it then okay for the department?
I don't understand what you mean by the council, the department admitted that they didn't make reasonable efforts. What do you mean by that?
In the transcript on page 102, the Mother's Council asks, were any extra efforts made to accommodate mother's disabilities? And the social worker says, I don't think there were.
So how is the department assuming they were on notice of her disability, how are they on notice that the mother found the services to be inadequate?
Well, they didn't provide services, so it should be obvious to them. Also, they didn't provide services that they normally provide, like a parenting aid. That's also in the record that this is something they typically offer, and they didn't offer it in this case.
Are you claiming any disabilities other than her mental illness?
She has intellectual as well as psychiatric disabilities.
Where do I find that in the record?
I think the judge actually mentions in her findings that she presents as cognitively limited, for one, but also the fact that she's working with DDS, the Department of Developmental Services. You can't have services from DDS unless you are intellectually disabled. So I don't have more support than off the top of my head, but I can certainly provide a reference if the judges would appreciate that.
What do you make of the fact that your client testifies that she wouldn't be willing to do anything on her to-do list?
I don't remember that being the testimony. I remember, okay.
On page 57, would you be willing to do more on your to-do list if it helped get your child back, like me with a housing specialist? Answer, no.
I think this is a real challenge given her intellectual disability, because what it seems like to me in that section of the transcript is that she is solely focused on housing because in her limited way, she thinks that's what she needs. So.
But if she won't accept services unless she's given a house first, what's really the harm from the department's failure to give her more services?
Your Honor, I don't know that that's true. I just don't, her testimony, she struggled so much to even to testify or to be in the courtroom. I think without more evidence of her intellectual disability and how that impacts her functioning, how it impacted her testimony, even that I don't think it's actually clear, even if she says no, that she's unwilling. And also she tends to change her mind frequently. So it may depend on how the question is posed to her and by whom. think there's too little evidence in the overall record to really know, even when she said no, if that's true. And I think that's the problem, really, in terms of the systematic discrimination, the kind of policy of the department that they have right now of basically taking children from disabled parents and placing them in non-disabled parents that they choose. They didn't address the systematic discrimination. They are still practicing it. And without someone, this court or the legislature saying, no, look, you really have to do what you're supposed to do before taking the extreme step of forever terminating this family, of ending it, that I think public policy says that they should not be able to continue to systematically discriminate in this way. And so Mother respectfully requests that this court vacate the trial court's decision and remand to the trial court for DCF to accommodate Mother, and for the court to issue a decision that is sufficiently detailed to comply with the rules and decisional law. Thank you.
Thank you, Attorney Custer. Are there any other questions? Okay. We'll hear from Attorney, is it Hotch from the Attorney General's office?
It's Hoke.
Hoke, great.
Yes.
And so actually you have 10 minutes. There you go.
Yes. Good morning, Your Honors. Natalie Hoke for the Department of Children and Families. While the record in this case may not be voluminous, it is sufficient. What is abundantly clear from the record is that Mother was involuntarily hospitalized or in a group home setting for approximately 21 months by the time of trial, which was approximately 60% of her son's life by that time. The other 40% of the time, Mother was not receiving any treatment for her mental illness. She was not cooperating with the department, and her whereabouts were often unknown. And I just want to quickly comment on what Mother's attorney essentially just argued at the end of her argument. It appears that she's saying, and she's asking this court to make a credibility determination that Mother isn't credible on the witness stand. Mother testified, no, she didn't need any additional services, that no, she didn't want any help. No, that she was fine. She just wanted housing. And the social worker testified on page 102 of the transcript. I just want to clear that up as well. So the social worker herself was confused by the questioning. She was asked what reasonable accommodations were made for Mother's disability in this case. She didn't know what the attorney was saying. She said, I'm unsure what you're saying. And the attorney said, the department knew at points that she was psychiatrically hospitalized, correct? And Mother said, correct. And then she was asked, were any extra efforts made to address those issues? The social worker said, I don't believe they were. So I believe the social worker was confused, and the questioning was directly in line with Mother's physical psychiatric hospitalization, which the department didn't have anything to do with. So it communicated with her medical providers on a regular basis. It tried to make sure Mother was stabilized to the point where she could attend the parenting classes that the department did refer her to, that she could attend therapy sessions the department referred her to, that she could have parent and child visits that the department continuously set up for Mother, except when she was involuntary hospitalized, except Mother often canceled those visits or were no-shows. And even when she attended those visits, she was unable to care for her child. She relied on others. Mother makes a big deal about the department not offering any services at all. Over 3 years, the department completed 5 different assessments to determine how it could reasonably accommodate Mother's disabilities. The first 2 assessments in 2016 and 2017, Mother was not in any treatment at all. And at the end of 2017, Mother's whereabouts were unknown. In 2014, Mother's whereabouts were unknown until she was involuntarily hospitalized for almost a year. The last assessment, Mom was confused as she wanted her child to be her own guardian, and she demonstrated an inability to understand how to even parent her child. For example, when asked how she would keep him safe, she said she would buy him whatever he wanted, and if he cried, she would just take him to the emergency room. The department also made multiple referrals to therapy, drug treatment programs, parenting classes, support groups, mental health services, and they made multiple home visits to find Mother and made multiple phone calls when her whereabouts were unknown. There were 6 different.
Counsel, where is this in the record? The multiple
part?
referrals, the multiple referrals and the multiple home visits. Is that in the testimony?
No, I believe the home visits might have been mentioned in the testimony, but the referrals show up in 2016 and 2017, the service plans. And the home visits were the first, I think it was called an assessment worksheet. It's one of the first exhibits, and there's a list of all the phone calls that were made. There were multiple phone calls you can see made back and forth to different providers and home visits. Specifically, there was a home visit on July 6th, July 25th, September 12th, and October 5th, all in an attempt to track mother down when her whereabouts were unknown. Those home visits were unsuccessful. So the department did everything it could under the circumstances to determine what mother's needs were. It knew mother had a disability. It's not denying that. But the problem was mother was never stable enough by her own medical provider's admissions to even begin to learn how to parent her child. So the department was focused on stabilization first, but unfortunately after 3 years, mother was never able to be stabilized enough. And even after a whole year of involuntary hospitalization, she still remained unstable to the point where she, do you have a question?
You said a disability. Do you agree with your sister that mother had a disability beyond her mental illness?
I think the focus was on her mental illness disability. I think there was a mention in possibly the first assessment that there was an intellectual disability as well. But the main focus was on her mental health issue because that's what made her aggressive and unstable to the point where even the hospital and her medical treatment provider said she's not in a place where she can visit her child. Is that what you were referring to, her intellectual disability?
Mm-hmm.
Can I ask you, apart from, there's a strange echo there, apart from the response that it wasn't raised below, how do you respond to the claim of systematic or systemic discrimination against mentally ill? Suppose DOJ were to come calling and ask about this case, what would your response be?
I think in light of the Gordon decision, which isn't precedent and it's based on an individualized circumstance, here the facts are completely different. In the Gordon case, mom had a developmental disability. Her parents were planning to be the child's legal guardians, and she had difficulties taking care of her child, but her parenting skills had vastly improved. And several professionals stated that the plan of sending the child back to her to have her parents help her parent this child was a good plan. Here, mother never had anyone testify that mother should be reunited with the child. She never had anyone testify that additional services would have helped. If anything, the court found that even a parenting guide at the visit would have been at least at the very most minimal support, and that the department could not have offered any additional services that would have changed the outcome in this case. So while reading mother's brief, it does sound like, oh, there was a vast injustice that occurred here. If you break it down and read the record and you read the arguments in the department's brief, it's very clear that mother was never in the same position that Miss Gordon was in her case, where she was ready, able, and willing to learn how to parent her child, improving her parenting skills, and ready to accept the child back into her home with care. If anything, mother relied greatly on maternal grandfather. At the time of trial, he had moved to Florida, and the court found he wasn't a support for her. So mother didn't have any family support with her to then help her care for this child as Miss Gordon did. So it's vastly different circumstances. And so I would say that Miss Gordon isn't applicable here, even if it was precedent, which it isn't. So we just don't have that type of case because even if we did, at the end of the day, mother is clearly unable to parent her own child here, and the court has to decide what is in the best interest of the child. And here it is to affirm the trial court's decision. And I rest on my brief unless there's no further questions.
Seeing none, we'll ask Attorney Capulli to speak.
Thank you, Your Honor. My name is Attorney Mike Capoli. I represent the appellee child. May it please the court. I would mostly be resting on my brief as well as the excellent brief submitted by my sister from the department. The three main points I focused on in my brief were whether or not the judge found reasonable efforts, whether or not the judge's findings were detailed enough to support his conclusions, and finally, whether mother had timely raised the issue of reasonable efforts. I would suggest, I would argue that mother did not raise the issue of reasonable efforts, and therefore the issue should not be decided by the appeals court. I would ask the justice.
Although wouldn't you say this is a case like in Adoption of Chad, where the theme of her disability kind of ran through the entire case?
Yes. Well, I actually found this case to be most like the adoption of Iona. As far as the facts go, I feel it's very similar. And in that case, the SJC was extremely clear that the judge needs to find reasonable efforts, and that the higher courts, the appeals court and the SJC, give deference to the trial court judge's findings, because he sat through the hearings and listened to the evidence. So I believe this court should give quite a bit of deference to the trial judge. Excuse me. As it states in Iona around page 63, prior to terminating, it is a requirement that the trial judge finds reasonable efforts. In this case, there were 3 or 4 times, I apologize, prior to trial where the judge did find that the department used reasonable efforts. And as it says in Iona, even though there may be evidence of shortcomings that the department had in providing services to the parent, in that case mother, the trial judge's findings were of reasonable efforts were not clearly erroneous. And I think that's the case in this matter, that the judge had enough to make that decision. Furthermore, the judge found mother unfit in this case, and he, relying on testimonial evidence, came to the conclusion that there's a reasonable likelihood that unfitness is likely to continue into the indefinite future. And that's the problem for this child. There's some great language on in Adoption of Elena. Because childhood is fleeting, a parent's unfitness is not temporary if it's reasonably likely to continue for a prolonged or indefinite period. And I believe when you read the transcript, read the evidence, it becomes quite clear that in this case, mother's unfitness was certainly going to continue at least for an indefinite period because of her inability to engage in services, to engage with the department, to do what she needed to do. The department certainly was on notice that mother had a disability. I think that's clear from the record. And the department attempted many times. I think my sister from the department laid it out very well in her brief, the steps that the department took to engage with mother. And as you read through Attorney Hawk's brief, I think you really get that feeling where the department is trying at every step to engage with mother, and mother either cannot or will not engage with them. And at the end of the day, even though parents have a constitutional right to the intactness of the family unit, the child's best interests ultimately come to the forefront, and those are the grounds we have to make decisions on.
Okay, thank you. Are there any further questions? No, okay. So thank you all very much for participating. We'll take the case under advisement. These are strange times, and but thank you all for Zooming with us, and you all take care, okay? Are we good?
We are live.
Okay. So good morning and welcome to the Massachusetts Appeals Court oral argument session for June 12, 2020. As you know, this argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. Other than that, though, we'll follow the usual rules and customs, 15 minutes per side, no rebuttal. Once we get going, a clock will actually display to show the time, and only of course, one advocate can speak at a time. And in fact, the other advocate will be silenced during that time, but we will still be able to see you. So please keep gesticulations and reactions to a minimum. The proceeding is being recorded and archived, so it will be accessible to the public later, as it is at this very moment. This case has impounded names, so please refer to the parties by descriptions rather than by their names. As always, we've read your briefs and we're familiar with the case. And so calling this case, it's 19P1674 AJ versus EJ. And the appellant is AJ, represented by Attorney Curtin.
Good morning, Your Honors, and may it please the court. Stephanie Curtin on behalf of the appellant wife. Your Honors, the wife is requesting that denial of her request for extension of a 209A order be remanded to the lower court for further hearing. There are three primary reasons that this case needs to be remanded, Your Honors. The first is that the lower court failed to make the necessary credibility determinations and findings clear on the record to support denial of the wife's request for an extension of the 209A order. Where, in the absence of findings and appropriate credibility determinations, it's not possible to determine the basis for the court's ruling, the case must be remanded for further proceedings. This was made clear in IMLE versus Aslin, 444 Mass 734, where the court reviewed the denial of extension of a 209A order, and because the basis of that denial could not be discerned from the record, due to the judge not making any definition of the burden he believed that the plaintiff had to meet, that it was not clear in the absence of findings in what respect the court deems the plaintiff's case to be insufficient, measured by the proper standard, and without the benefit of the judge's credibility assessment, because the reviewing court could not determine whether an extension would have been required on the facts, or alternatively, whether denial was not an abuse of discretion, it had to be remanded for further hearing. And here, Your Honors, we have facts nearly identical to those found in IMLE. Only one party testified, the wife. She testified to physical abuse perpetrated on her by the husband on August 19th, 2019. She testified to pushes and shoves while holding the party's 5-week-old baby, threats that if she left the apartment without the husband, that he would make her and the baby suffer, and an incident wherein the husband followed her into a room after her request for space was ignored and grabbed aggressively the wife's breast, causing her pain. Although she requested that the husband stop, he refused to do so. The wife further testified to the history of anger issues, the unpredictable temper of the husband, that there had been kicking and pushing in the past, and also to her fear for her and her daughter's safety if a 209A order were not in place. The judge also heard conflicting summations of the standard required. While wife's counsel represented that she had met her burden by a preponderance of the evidence to show both harm or attempted harm under Section 1A of Chapter 209A and reasonable fear of imminent serious bodily harm under Section 1B, husband's counsel represented that the wife had failed to show fear of imminent serious bodily harm. The judge at that point interjected to say, that's the standard, so you know. The judge made no credibility determination on the record, made no written or oral findings, and did not state on the record whether he believed the plaintiff had met her burden. Instead, he simply stated, "I'm not going to extend it."
And the judge specifically agreed with the standard that you proposed. Why would we think that he didn't apply the correct standard, whether or not he applied it correctly?
Your Honor, that brings me to my second point here, which is if the judge had applied the harm or attempted harm standard articulated in Section 1A, there was uncontroverted evidence that physical harm was perpetrated on the plaintiff by the defendant. This went unanswered by the defendant by testifying, and in fact, husband's counsel had represented these facts did in fact occur. There were criminal proceedings stemming from them, and she classified them as an isolated event.
Is it your position that pushing, shoving 2 incidents on the same day by themselves would require an extension?
Your Honor, under the facts of this case, while the judge may have had the discretion to decline the extension had he not believed the wife's testimony that she had been pushed, shoved, her breast grabbed aggressively, causing her pain, had he not believed that, then perhaps it was in his discretion not to extend the order. The problem here—
What I'm trying to say is that the pushing and shoving seems essentially uncontested, almost admitted by defense counsel, not the breast squeezing. Is the pushing and shoving enough to require a judge to extend the order, in your view?
in every case, that's not the case, Your Honor. The judge still has the discretion. Even under Section 1A, we're not advocating for a position where the judge must automatically extend every time there is a push or a shove. But here there was testimony beyond a push and a shove. There was grabbing of the breast, there was pain caused, there was a history of aggressive tendencies, throwing things, pushing things, and testimony as to fear for the wife's safety in the context of the escalation to physical violence and the threats made by husband on August 19th. So there's more there than the simple push and the shove that Your Honor is referencing.
If this is remanded, how would you anticipate that remand hearing looking? Would it involve everything that's happened since August 30th, 2019? Would it be limited to what had happened by that date? How would it proceed?
Your Honor, I think a remand at this point in time could consider the events since the initial issuance and the denial of the request for extension on rehearing. If the judge were inclined to review the incidents that have occurred since August of 2019, but it would need to be reheard to address the testimony received on August 19th as well, to determine whether the judge at that point in time had enough to decline to extend the order, as there's serious conflict in the record about whether he credited the wife's testimony. Which brings me back to my argument, Your Honor, which is that here that there's a lack of clarity about whether the judge credited the plaintiff's testimony. The judge's questions here focus primarily on what outside protections were in place for the plaintiff. He questioned whether DCF was involved. He questioned whether there was a stay away, no contact, or no abuse order out of the criminal court proceedings. This gives rise to a reasonable inference that the judge believes that the plaintiff needed protection. That's why he was asking those questions. And in this situation, had he credited the wife's testimony, it should have been extended. Because that wasn't made clear at all in the record, it does need to be remanded for further hearing pursuant to the standards set forth in IMLE.
So even if there was, you make a claim about misrepresentation about the status of the criminal case, but even if there was an active no contact or stay away order in the criminal case, would that be a basis for denying a 209A?
It would not, Your Honor, and that's why I referenced in my brief that that's putting aside the argument that the judge in that case, had he premised his denial on an active stay away, no contact order, was still outside the bounds of what he was to be evaluating in the context of a 209A proceeding. Your Honor, the judge should have been focusing his analysis on whether there had been harm or attempted harm, or alternatively, whether the plaintiff was in fear of reasonable fear of imminent serious bodily harm. The protections in place in another proceeding, Your Honor, would be irrelevant considerations in violations of the principles set forth in McDonald v. Caruso and CO v. MM, where it was held to be an error of law to rely on those improper factors beyond the bounds of the 209A factors in extending the order. And as Your Honors are well aware, the protections afforded in the as conditions of pretrial release do differ from a 209A order as well. And for that reason, it would be improper to rely on them, even if they were actively in place.
So you don't think the presence of other protections is relevant to whether there's a continued need to protect the plaintiff by issuing a 209A?
Your Honor, I think that the standard, I do think it's a relevant consideration, but at this juncture, the standard under a 209A is whether there's harm or attempted harm and whether there's reasonable fear of imminent serious bodily harm. There's a constellation of factors that the judge needs to take into consideration. And I think including, whether there are other proceedings likely to engender hostility between the parties, which in this case there certainly was. There were notes made about the continued divorce litigation, as well as an active criminal matter, and taking as a whole, while it could be considered, the fact that there are outside protections alone is not sufficient to deny a 209A order where the findings can be made that there was fear of imminent serious bodily harm or attempted harm under Section 1A. It doesn't alleviate the necessity that the plaintiff have those protections under the appropriate order. It would in fact be contrary to the public policy objectives of 209A, which is to protect the fundamental human right for protection from family abuse, to say that this, just because a criminal court proceeding is in place, that the plaintiff isn't entitled to the protections of 209A. It would actually create a situation where if a criminal case were proceeding, the plaintiff would be entitled to less protections, akin to the analysis in Callahan, where because the defendant there was incarcerated, she was still entitled to the protections of a 209A, noting the public policy contradiction and denying a plaintiff's right under 209A simply because a defendant was incarcerated.
Whereas here, the judge is misinformed about what's going on in a criminal case, why don't you have a duty to file a motion for reconsideration, correcting that and seeing whether that changes the judge's decision?
Your Honor, I think here that there's not a duty to file a motion for reconsideration because it wasn't clear that was the only basis for extension of the order. In fact, the problem here is that there wasn't a clear basis for denial of the extension of the order. Your Honor, it wasn't, I think there was also reasonable reliance on husband's counsel, given that she was involved in this very criminal action that she was representing to the court the status of, and given that we would have expected candor to the tribunal relative to that status. Additionally, Your Honor, this is beyond the problem of just the misrepresentation. The bigger and larger issue here, Your Honor, is that it's unclear whether that was the basis of the judge's decision. And for that reason needs to be remanded so that it can be made clear and discernible in the record what the judge was thinking here, as opposed to speculating as to the reasons for the denial. This brings me back to my argument relative to credibility determinations. This case is also distinguishable from the cases where it was held that specific findings and recitation of the standard were not necessary. In those cases, there was at least something in the record which made clear what credibility determination the judge had made. For example, in GB versus CA 94 Mass Appellate Court 389, the judge did just that. The judge there had at least made the finding that the plaintiff had met her burden. And in that case, sets forth the juxtaposition of the two sort of lines of thinking here, comparing the Ginsburg case, where the decision and the questions the judge asked clearly showed the credibility determination that the judge had made there, and IMLE, where it was not clear in the record. As I've stated previously here, the record is replete with contradictions. It seems the judge was concerned about the plaintiff's safety enough to inquire about outside protections, yielding the inference that he had credited her testimony, yet that's at odds with the decision not to extend.
In terms of the, in terms of the lack of findings, Suppose that instead, at the end of the trial, instead of the judge saying, I'm not going to extend it, the judge had said, I'm going to extend it. And that was all. Would Mr. Lazar have a good case that should be remanded?
In that case, I don't think he would have a good case that it should be remanded, because there would have been consistency in the record and a discernible basis for the decision. Here, the record indicates, based on the questioning of the judge, that he accredited the plaintiff's testimony. Her testimony went uncontroverted. She was the only one who testified. And there, I think we could say it was more akin to Ginsburg, where it was clear in the record that the judge had credited the wife's testimony, and that was the basis for extension of the order. Now, I would say, if you were asking what the court should do, ideally, in each case, we would have findings of fact, at least basic ones to explain the judge's rationale in basic terms. But at the very bare minimum, there needs to be a clarity in the record about the credibility determination and whether the judge believes the plaintiff had met her burden. The problem here is that we have neither of those.
I'm concerned about a situation in which we tell district court judges that in a volatile domestic violence situation like this, they have to end their hearing by saying, I don't believe the woman, I don't believe the man. Why am I wrong to be worried about that?
Your Honor, I don't think what I'm advocating for is a recitation of the credibility determination on the record. What we're looking for here is a bare minimum understanding of what the basis was for the judge's decision. And in this case, it could have taken the form of saying that based on the credible evidence that the plaintiff had met her burden or had not met her burden. But what needs to happen is that there be some indication in the record and clarity as to how the judge was arriving at his decision to support the public policy objectives, both for litigants to understand the rationale for the judge's conclusions, and also for the reviewing court, such as yourself, to be in a position to assess whether the correct standard was applied and whether the facts were appropriately applied to the law, which can't be done in the absence of a clear indication on the record.
Okay, your time is up and I don't see any further questions, so thank you very much. Mr. Lazar, you've already been unmuted, so you have the floor.
Good morning, Aaron Lazar for the defendant. Judge O'Malley didn't abuse his discretion and he properly applied the law when he denied the extension of the restraining order. The wife has misconstrued the O'Malley versus Asseline findings in her brief in her argument. O'Malley doesn't direct that an order predicated on actual physical harm should be extended without question. And wife's counsel kind of touched on this in her argument and said that wasn't her argument, that it should be extended without question, but that's what her brief seems to say. And what I would say is that the O'Malley case, which is the crux of the wife's argument, really says that a judge needs to look at the totality of the circumstances at the time of the hearing, in this case, the extension hearing, to determine what was in the best interest of society. Now, the wife's argument really hinges on current suffering, as noted in note 3 of the O'Malley case. What I would say is that she has not at the hearing shown current suffering. And if you look at the O'Malley case, which is, I would say, factually much different than our situation, there was current suffering by the plaintiff over a long period of time in the O'Malley case. In our case, there is no current suffering. And again, the key word here is current at the extension hearing on August 30th. She had left the marital home, had gone to her brothers in Sharon, had the protections of the police, and had not been in contact with the defendant since the incident itself.
Well, don't the cases say that a compliance with a court order not to contact the plaintiff in this situation, that doesn't really count?
Right, but what I'm saying is that, and again, just looking at that one factor in the totality of the circumstances. So again, it's not just whether or not there's current, the word here is current, but if there's abuse, that's just one of the factors. And to my next point, that the wife didn't meet her burden under the totality of the circumstances. Judge O'Malley clearly took into consideration a lot of different things. And if you look at the testimony, he considered DCF involvement, police involvement. He took a recess to look at the defendant's criminal BOP. He asked or heard about criminal conditions in the case out of West Roxbury, he was able to see the party's demeanor in court, physically see these people in front of him. He heard about a divorce proceeding being filed and served on the defendant that day, and he heard about the history of the parties. So he was in the. Go ahead.
Concern, though, that instead of considering whether the standard for a 29A order was met, the judge was considering the criminal case, the divorce case, DCF, instead of doing what the law requires.
No, I think he was actually following in line with what the law requires by not only looking at whether or not there was some abuse that happened that caused the ex parte order to be issued, but also the circumstances otherwise in these parties' lives. That there was DCF protection involved, that there was police protection involved, that there was an arrest, that there was a criminal case out of the West Roxbury division of the Boston Municipal Court, that there were conditions of release that were relevant to this situation, that the defendant had a lack of a criminal history at that point in time, and also that they would be going through the divorce process in the family and probate court, and there are obviously protections that through the divorce court, that motions that can be filed, things like that. So I would say that he was taking in everything under the law and looking at everything and making the best determination.
I believe that even if the judge credited everything, not just the shoving, but the breast grabbing, the threats, that the judge still would have the discretion not to extend.
Yes, based upon, again, the totality of the circumstances, what he saw at that specific time. And that's why he was the best person, or is the best person, to make this order, and why he has discretion to make this order, because, again, he heard about DCF being involved. He asked questions about DCF being involved. He heard about the police being involved, and then a criminal case, and heard about someone with a lack of a criminal history now being charged in criminal court. And obviously heard about these other things that I've listed off before. So
should those really be valid considerations? One thing is someone has pled guilty and has a probationary term, but we're talking about pretrial orders of release. Those can be changed. The case could be dismissed. And a DCF case could go away. Is it really valid to rely on that when those things are ephemeral?
I think so, because you have to look at, again, this is a snapshot in time of August 30th, what was going on at that point in time. And these are actual protections at that time. While a criminal case could be dismissed, while DCF could close their case sometime in the future, that's not the consideration in front of the court on August 30th. It's whether or not there are other protections in place and under a totality of the circumstances a situation. So while that is true, obviously, criminal cases can be dismissed, pled guilty, a number of things can happen, pretrial probation. It's a snapshot in time on August 30th.
No, I mean, counsel, Attorney Curtin argued, and if they got some force to this, that so you would be more likely to give a 209A against a defendant who doesn't have criminal charges, as opposed to somebody who's arguably a more serious threat and does have criminal charges.
Not necessarily. I think, again, you have to look at the totality of the circumstances in the situation and all the other protections that were in place. Somebody who doesn't have a criminal record and now has a criminal case and has conditions of release where he knows that he needs to abide by these things. So not necessarily. And that brings me to a point that Attorney Curtin made about articulating a standard and making a credibility finding. It's my argument that Judge O'Malley didn't need to make some sort of specific finding on the record. And I would say that's impractical in a busy trial court, in a district court. He clearly thought about what was going on. He asked questions of the parties. He asked questions of attorneys. He took a look at a criminal record. He took a recess to look at a criminal record. He read a police report and then made his finding. And as it came out during Attorney Curtin's argument, he acknowledged her statement regarding the law. So he doesn't need to make some sort of specific finding or read off something to say some sort of magic words to make this thing okay. He did make a finding by saying that without asking all these kind of questions and reviewing things. In terms of the wife's argument about the conditions of release, and there were some questions about this. being misstated. What I would say is that has been waived, as my brief says. That was never brought up on a motion to reconsider. There was never anything, a motion to clarify the record. There was nothing ever filed in the Stoughton court to address this issue, and it wasn't even raised until the brief filed in the appeals court. And that's the adoption of Mary case that stands for, generally speaking, an argument that's not brought up in the trial court has been waived. I'd also say that the
So, counsel, is it your position that let's say the judge believed the plaintiff's testimony that she was in fear of the defendant, and the judge thought that that fear was reasonable? Is it your position that nonetheless it would be proper for the judge to deny the extension because of the presence of other protections?
No, I don't think he found her fear to be reasonable, objectively reasonable at the time. And again,
I'm asking
that was.
So I'm asking you to assume that the judge credited the plaintiff's testimony that she was in fear and could have found that the fear, let's say, believe that the fear was objectively reasonable. Would it then be proper to deny the extension just based on the other protections?
Yes, because this was an isolated incident, which he already found, and he also found that there were other protections in place, as you just said. I would say
what in the statute allows a denial of an extension on that basis?
Well, there's no words about a denial on that basis. It's an objectively reasonable standard. So I think that if he found her to be in fear at the time, but it wasn't reasonable in that situation, given all these other protections, that he could deny the restraining order.
I hate it when judges do this to me, but Justice Shin's question was, assume that he did find it was reasonable. If this, in other words, the basis for a 209A under abuse definition B were met, could he still deny it based on the fact, well, there's other protections. He's got a no contact order in the criminal case.
And I think that's what the O'Malley case says, is that, and some of the other cases cited in the brief, that you can take a look at the totality of the circumstances to see if there's something else. And so
that goes to the reasonableness. That goes to the reasonableness of the fear, though.
Yes. Thank you. Yes. But to go back to my point about it being moot, there's now a moot issue in this situation, in this case. The defendant was placed on a pretrial probation, as the court knows, out of the Stoughton District Court back on December 19th of 2019. The appeal filed by the wife was filed in January of 2020. So practically speaking, this is moot because he is under the conditions of a stay away, no contact, while the defense counsel at the restraining order hearing may not have stated the conditions of release in a criminal case correctly. I think she was misinformed about that. The conditions are now of his pretrial probation that he stay away and have no contact with wife, except for orders through the probate court. That pretrial probation extends until September of 2017.
2020?
I'm sorry, 2020. Yes. I was thinking September 17th. 2020. So it actually goes past the annual renewal date of the restraining order, which would have been August 30th, 2020. So I think that you have to look at that as well. We have an issue now being moot. Now we're roughly 10 months or so out from August 30th, 2019. Any of these conditions have been in place for quite some time now. There have been no problems. We are obviously still going through the probate court with divorce. And that brings me to my last point about the appeal being frivolous. Plaintiff's counsel, wife's counsel knew about all these things before this appeal was filed. She either knew or should have known about the pretrial probation. It's obviously on the docket. It's in the record appendix for this court that was entered into on December 18, 2020. She, I would say, misconstrues the arguments in Amale, which makes this appeal frivolous. This reference to the appeal has been brought up in the probate court process throughout this whole thing, in that it's been used to try to show that there's been some sort of underlying restraining order when in fact it's been denied. So we've gone to court, and I represent defendant husband in the probate court. We've gone to court a few times, obviously, on temporary orders type of things. And this has been brought up, to best of my memory, once or twice, that there's an pending appeal to the restraining order in referencing the actions of the parties. And so I would say it's being kind of used to twist litigation in the family and probate court to benefit the wife. And that's all I have. Thank you.
I see no other questions. So thank you both for your arguments. Very interesting case, and we'll take it under advisement.
Oh, okay, we are live.
Okay. So good morning and welcome to the Massachusetts Appeals Court oral argument session for June 12th, 2020. As you know, this argument is being held on Zoom and being live streamed on the Appeals Court's YouTube channel. Other than that, and other fact that you do not have to stand, we follow the same rules as in court. We've read your briefs. Each side gets 15 minutes. There's no rebuttal. You'll actually be muted when it is not your turn to speak, although we can still see you. So please keep gesticulations and such to a minimum. Just for information, this is being recorded and will be available afterwards as in archive form. So with that, Attorney Mannion.
Thank you. Good morning.
I'm sorry, don't start the clock yet. The case is 19P 1264 Commonwealth versus FEIJAO.
Yes. Good morning. May it please the court. My name is Laura Mannion and I represent the defendant appellant Marcos FEIJAO. This is the appeal of the denial without any kind of hearing of the defendant's motion to vacate his guilty plea on the basis that although he was advised by his attorney that there may be some immigration consequences, including the possibility of deportation, he was not advised that due to his particular status, his deportation was not simply possible, his conviction was not simply grounds for deportation, it ensured it. The motion judge, who was not the plea judge, applied the familiar two-part standard, but he stopped after the first prong of the test for ineffective assistance of counsel because he made a credibility finding based on the submissions that the trial attorney advised Mr. FEIJAO that his conviction would be grounds for deportation. It's in the record that I was not able to get an affidavit from trial counsel. However, there was an email that was submitted as part of the record, which the motion judge clearly relied upon in concluding that the advice was correct. And the motion judge made an error of law when he concluded that that advice was correct as applied to Mr. FEIJAO. Commonwealth versus De Jesus is exactly on point here. And it is impossible to distinguish the advice that De Jesus's attorney gave to his client with the advice that Mr. FEIJAO's attorney gave to him.
So actually, Judge Rufo did distinguish De Jesus, and the way he distinguished it was he said that in that case, the defendant pled guilty to possession with intent to distribute a Class B, whereas your client was only pleading guilty to possession. Does that make a difference?
It doesn't in this case. It might in other cases. If, for example, if the defendant was a legal permanent resident who satisfied several other conditions, he might have been eligible for cancellation of removal in immigration court. But due to this client's particular status, which the SJC talks about in Commonwealth versus Pettit Home and Lavernenko, the importance of looking at the client's particular status, he had no defenses available to him in immigration court.
And so his status is what?
He entered without inspection as a child with his parents, and he had applied for and was granted DACA status. He was in the process of applying for what's called a 601 waiver. Because of the way he came into the country, although he was married to a US citizen, which ordinarily would have been able to confer additional legal status for him, this conviction foreclosed the possibility of that. So at the time of his plea, he had DACA status and was undergoing the process with the hope and plan and expectation, quite frankly, he had gone through and already been approved of half of it to obtain legal status, which in turn would have made him not deportable.
Can you tell me what are the specific federal statutes that make him make him automatically deportable?
Yes. They are in my brief, and I'm sorry if you can just give me 1 second.
They are. You said all the relevant ones in your brief.
I do, and I can summarize them. I just can't give the numbers.
Go ahead. But summary be fine. Like I can look at your brief.
In order for someone like Mr. FEIJAO to not be deportable on the basis of possession of a controlled substance, and again, possession, straight possession. In his case, it's no different than if it would have been possession with intent to distribute or another aggravated felony. Because of his specific immigration status, which is somebody who was undocumented, had been conferred DACA status, which is not really legal status, but it's more of a promise not to deport. And he was married to a US citizen, someone that he met in high school, 6 years before his plea. They'd been married for 4 years at the time of the plea. They had a 2-year-old son. He would have been able to, and had been in the process, in fact, of, on the basis of that marriage, obtaining legal status. And he would have been able to obtain eventually permanent residency here. But in order to, the conviction the conviction here, possession, simple possession, doesn't mandatorily require deportation in the way that aggravated felonies do for everybody. No matter what your status is, if you're convicted of an aggravated felony, you can be a legal permanent resident who's been here their whole life. If you're convicted of an aggravated felony, that's it. Your deportation is presumptively mandatory and practically inevitable. For Mr. FEIJAO, he needed to be admissible. And that's the statute that Your Honor was referencing. There's a statute that requires admissibility in order to adjust his status, which would be his only possible defense in immigration court, through his marriage to his US citizen wife. And a drug possession conviction of any kind, except for a minor amount of marijuana, it makes someone permanently inadmissible. And because he was inadmissible, his deportation was assured.
And that seems to me to be one distinction with De Jesus, which is that the federal statutes are much clearer about the consequences of having a conviction of an aggravated felony as opposed to just a possession charge conviction.
It is, but
I mean, you have a criminal defense attorney here who consulted with an immigration attorney, followed guidance that was given to him by CPCS, showed the defendant the chart, which accurately stated that even a possession conviction would render the defendant deportable, which the defendant signed. And yet we are to find that fell below the level of an ordinary attorney. I find that very difficult.
Yes, Your Honor. Pettit Home, an SJC case that was decided shortly after the motion had been filed and denied in the Superior Court, that case is all about the idea, well, it's in the 29D context. It's in the context of the statutory 29D alien warnings. But the thrust of it is that there are there's two grounds of deportability, essentially, if you want to very much simplify things and make it very reductive. There's something like an aggravated felony that unless you qualify for Convention Against Torture, you're going to get deported no matter what, is the simple plain English way to say it. And then there's everything else, which there's always some conditionality to it. There might be some form of discretionary relief available to almost anybody else except for the aggravated felonies. And especially for a minor charge of possession, somebody with no criminal record, somebody who had a US citizen wife and son, he would have been a very good candidate to proceed with the application that had already been filed and partly approved. So although the statute itself, and there is language in Petit Home specifically about it, the attorney has to look at not only the specific statute, because the trial attorney did that.
I understand that, but that's really my point, which is the SJC and Petit Home said several times that this is a very nuanced and complex determination. So what kind of burden are we putting on criminal defense attorneys? It just seems to me that you're putting a very difficult, imposing a very difficult standard on a defense attorney to sort through these very complicated statutes and give that kind of advice, the kind of unequivocal advice that you're saying should have been given here.
I understand that, Your Honor. The SJC is they set that standard. It is a very high burden. It's very difficult.
I mean, there are distinctions with De Jesus in my view. Let me ask you a different question. What kind of obligation did plea counsel have to look into how a plea would affect the defendant's DACA eligibility?
That's a good question. As far as his DACA eligibility, yes, he would have had an obligation to look at his client's particular status. In Petit Home, in Lavranenko, you have to look at the effect that it's going to have on your particular client. It's not enough to see that your client is a non-citizen. If your client is a non-citizen who will have no possibility of staying no matter what, it might as well have been for an aggravated felony. Trial attorney has a duty to do that. And as previously referenced, he did have an immigration attorney. And there is no evidence that anybody ever informed him of the inevitability, the presumptively mandatory nature.
So it seems like even the immigration attorney was not able to give him that kind of unequivocal advice, perhaps partly because of his status that he was could be eligible for DACA. And I was actually wanted to ask you about something in the defendant's own affidavit, where he said that while he was in the House of Correction, he was visited by immigration, who also said that because of his DACA eligibility and being married to a citizen, that once he got to immigration court, that he would not be deported. So it seems to me there are so many unknowns surrounding his status, and yet we're supposed to find that the plea counsel was ineffective for not researching all of these issues.
They were not unknowns, and the ICE officer was mistaken. And I've seen it before. It does happen. Often it's just kind of assumed that because you have, well, first of all, even though DACA isn't a legal status, it is a benefit, and you have your US citizen wife, it's presumed that most people could have a decent shot at least of not being deported if they can file for cancellation of removal or something like that. But his immigration attorney absolutely knew that a conviction for possession of a Class B substance would result in Mr. FEIJAO's mandatory deportation. I don't doubt that in any way. The affidavit doesn't necessarily say that. The affidavit's written a little bit vaguely, which is why an evidentiary hearing would have been useful. But at all times during the many meetings that Mr. FEIJAO had with his immigration attorney, it was talked about in terms of the pending charge may have severe consequences. There's a possibility.
If we think that defense counsel acted within a reasonable, fallible attorney, but that the immigration attorneys did not.
I don't think there's a basis in the record for that, because trial counsel is the one with the duty under Padilla, under the Sixth Amendment. His immigration attorney, certainly it would have been better had there been more communication between all of the parties. But the immigration attorney, regardless of what he should have advised, it was the criminal defense attorney who has this job, and it has to be part and parcel with the conversation about the risks and benefits of going to trial in a case where He was in a car that he didn't own or operate. He was the passenger. The backseat passenger had been the subject of a 2-month-long investigation. He was found, the subject of the investigation was found with $900 something, 90 of which was controlled by money. The drugs were found in a woman's purse on the floorboard of the car, which is where Mr. FEIJAO was sitting, but the floorboard of the passenger seat in the car is where a woman's purse is not unlikely to be. And Mr. FEIJAO knocked over this purse and spilled out the drugs and knew that they were there. There is this case, as Judge Nickerson himself repeatedly said, this is not the strongest case for the government. The possession with intent.
Can I ask you one more question back on the what's expected from counsel? The chart, the CPCS chart, is that wrong as to a client, a person with your client status?
Yes, it is. And the rest of the CPCS guide makes very clear, as did CPCS wrote an amicus brief in Pettit Home, talking about all of these complexities and that you cannot just look at this as all immigrants being the same across the board. This is wrong because no, it's not true. He's not deportable. He's not eligible for deportation. His conviction's not grounds for deportation. He will be deported, the same as DeJesus. So the chart, it's just a beginning. It needs to be, you need to go a little bit deeper as the attorney, and that did not happen here.
Okay, thank you. Any other questions? So your time's expired. So thank you very much for your argument. We'll hear from the Commonwealth.
May it please the court, Karen Palumbo for the Commonwealth. I would suggest, Your Honor, that defense counsel in this case was not ineffective. This court has not held the specific language that needs to be spoken in order to convey immigration consequences to the defendant, but it has found that the information has to be presented in a way that the defendant can understand it. And I would suggest in this case, defense counsel did exactly that. First, his email, he said that he advised him in his office prior to trial that a guilty plea for even a possession charge would be grounds for inadmissibility and deportation. And I believe inadmissibility is what defense counsel is speaking about in this case. Defendant was at a point in his green card process where he was about to return to Brazil and he would have to go through the consulate. If he did that, based on this conviction, he would be inadmissible, so he could not come back. So I believe that's where the inadmissible comes in and is important. But
is it different to say grounds for inadmissible as opposed to you will definitely be inadmissible and deported?
I believe grounds is a basis for, but again, this court hasn't held that those specific words need to be spoken in order. And I would suggest that the chart that
isn't there something in the DeJesus and Leverenko, whatever, about it's got a reasonable certainty, like it's pretty much certainty of deportation or something like that?
If it's mandatory and inevitable.
Mandatory and inevitable.
But those words, the court has not decided that defense counsel needs to say those words. Only that defense counsel has to make it clear to the defendant what the consequences of a guilty plea would be. And defense counsel, he did say grounds for deportation, and the court may find that's not sufficient, but he did show the defendant the consequences chart in which he circled possession of a Class B substance. And he showed the defendant that he would be inadmissible and deportable. And he had defendant sign the form, suggesting that the defendant acknowledged that he received that information and understood it. And I would suggest that satisfies the burden on a defense counsel. As far as
isn't deportable the same thing as grounds for deportation?
I guess, yes, it is, but that's what the statute says. You're deportable.
Right. I mean, but the statute is accurate, but I'm sorry, the chart is accurate. It's not wrong, but your sister's argument is it's incomplete, and it's hard to distinguish DeJesus on this issue. The difference between grounds for deportation versus eligible for deportation.
Well, I think eligibility suggests that there has to be something more. It's grounds for deportation. If you're convicted of this offense, that is the ground on which they can deport you. And this defendant also had the benefit of immigration counsel. At first, when he first obtained them, they inquired about his criminal history. When they found out about this new charge, he was told that it would make him ineligible to pursue the 601A waiver, which he needed in order to be allowed in, and it would affect his eligibility for DACA. They again told him that they couldn't move forward with the green card or renewing DACA, and they did say it would make him potentially deportable, but they also closed the case because there was no further action that they could take in the matter. Now, I would suggest both of those things from defense counsel and immigration counsel were sufficient to put the defendant on notice that he was going to be deported if he pled guilty to this charge. And the defendant, even though in his affidavit he admits that he spoke with both immigration counsel and defense counsel, he does say that he never thought he would get deported. I think that's unrealistic given the advice that he was given by counsel. Also, as far as prejudice,
I think his understanding of the advice from immigration counsel was that the pending charge meant that he couldn't go forward with his green card application, but he still believed that once the charge was disposed of, that he would then be able to pursue it again, and that's in the affidavit.
I'm sorry, excuse me?
So that the immigration attorney's advice was about the pending charge. It didn't have anything to do with the conviction or the plea.
The second time he spoke after he pled guilty with immigration, they told him that they couldn't move forward.
That's right, that's after he pleaded guilty. So I mean,
Yes.
my understanding is he spoke to the immigration attorney several months before he actually pleaded guilty.
Correct.
And the immigration attorney advised him about the consequences of the pending charge, but he never actually received advice about the consequences of the plea. Is that accurate from the immigration attorney?
From the immigration attorney, no, but he did speak with her after he had pled guilty. But there's no indication that he had any conversation with her about pleading guilty to the charge. Okay. As far as prejudice,
Not yet. It seems to me that this is complicated. I mean, and De Jesus, maybe it almost comes up to almost a strict liability type of issue, and that seems kind of inconsistent with the standard of what an ordinary fallible attorney would do. But so in this case, where it is so complicated and there's so many moving parts, doesn't it make sense to have an evidentiary hearing to find out what ordinarily fallible counsel would do in these circumstances?
I disagree in this case. I think the judge properly ruled on the motion on the papers before him. He, although he was not the plea judge, he was the motion to suppress judge. He had observations of the defendant, and he was the proper judge of credibility. And given Attorney Lloyd's submissions or submissions from the defendant of Attorney Lloyd, the court found that he was properly advised, and he maybe chose not to listen. As far as
prejudice. Yeah. So you have any doubts that there's special circumstances here for this defendant?
It seems clear to me at the time. In that respect, this is very close to De Jesus. But at the time of the plea, the defendant wanted to spend as little time in jail as possible, and he made that clear. And in fact, he said that he decided to plead guilty because he thought he might get a longer sentence if he had gone to trial and lost. And he kind of flew under the radar after usually ICE detains people at the end of their sentence. The defendant was released, and he wasn't arrested by ICE until November of 2017. He flew under the radar for about a year or so. But I would suggest not in this case. He at the time was not having a good relationship with his wife or his child. He was living with his parents. So I would suggest no. And I would suggest, given Attorney Lloyd's advice, especially the consequences sheet, that there's no need to reach the prejudice issue.
Do you think there's a theory of ineffective assistance of immigration counsel?
I don't see how that would apply to this case. Maybe he could bring a charge separately, but immigration counsel isn't, first off, there is no claim against her. for ineffective assistance of counsel.
I guess I'm asking if a judge finds that defense counsel acted reasonably, but immigration counsel that was consulted gave bad advice. You could certainly imagine someone who's told by his defense lawyer, oh, this might make you deportable, and told by his immigration lawyer, no, it won't, would reasonably believe the immigration lawyer. Is that a theory under which someone can move to withdraw a guilty plea?
I don't believe so. And in this case, we don't have that. The immigration attorney did not advise the defendant that he would not be deportable based on this conviction. She advised him that there was a possibility of deportation and that he was no longer available for DACA or the 601A waiver form. So for the reasons in the Commonwealth's brief, I would ask this court to deny the defendant's motion. To affirm the denial of the defendant's motion. Thank you.
Okay, thank you both. Very interesting case. We'll take it under advisement, and thank you for participating with us on the Zoom conference. Have a good weekend and stay well.
Thank you.
And that will resume, we'll adjourn for today.